We're going to be talking about employee grievances, disciplinary matters, and internal investigations. Now, I'm not going to talk for a really long time on this matter. I could talk all day on this, but let's just get through some of the really high level stuff so we can get you thinking more about how to get it more right more often. How do employee grievances, disciplinary matters, and internal investigations link? Well, it's kind of an easy one. Grievances lead to disciplinary matters, which, grievances lead to internal investigations, which lead to grievances lead to internal investigations, which lead to disciplinary matters. So of course they all link. So each step of that way, you need to get it more right more often. You need to document it. You need to have the right balance of independence and knowledge. You just need to really think about these things, because if your employee is going to start some sort of action against you, an unfair dismissal, general protections, discrimination, breach of contract, all the other things that they can do to you in relation to these, in relation to something that might end up in a disciplinary matter, then you need to make sure that you can protect yourself and show that you've done this investigation properly. What do I do if an employee has a grievance? Now, if you're a big company, you probably actually know the answer to that question. You follow the procedures, you get someone involved who knows more about it than you do, and you get it all right. If you're a small company and this is the first time someone's come to you with something that's actually a little bit unsavoury, you might want to stop and have a think about it, take a breath, stop and ask more questions with that person. Tell them that you need to go back and get some more information. Get the time that you need, and most of all, don't snap back an answer and say, I'll get back to you this afternoon on that, because you might find that you've dug yourself a very large hole that you're going to have to try and climb your way out of. So try to take a measured response. An employee has raised some serious allegations about sexual harassment in the workplace. What can we do to protect this employee until the conclusion is reached? Now, okay, there are two people involved in this, in my view. You've got the employee who's made the complaint, and you've got the employee that's been complained about. Now, obviously, at this very early stage, unless you actually witnessed it, you don't know the answer. You don't know who's right and you don't know who's wrong. Yeah. So first of all, you need to protect both of those employees. If they're working very closely together, figure a way to separate them so you're not treating the employee who made the complaint adversely, but also you're not having a predetermined outcome for the employee that got it wrong. One way of doing this is just standing down the employee that's under investigation while the employee that made the complaint can carry on with their job. There's a lot of other ways to do it. That's certainly not the only way, but certainly start thinking about it in those lines of thinking. Don't just keep them together and go, they'll get along, don't worry. Once we figure this out, it'll all go back to right again, because it very rarely does. So you're protecting the employees also by maintaining their confidentiality. Make sure the support people that are coming in and having these meetings with the people you're talking to are independent enough and not going to be talking about this matter amongst other people in the business. Make sure that you've separated out the information, you've put up paper walls, or you've got an independent person coming and looking at it. And most of all, make sure you have an independence that makes sense. I have a lot of employees coming to complain to me about a disciplinary process or an investigation that's been investigated by the best friend of the person who made the complaint. Probably not a good idea. If it ever gets tested, you are going to get slammed. The other thing that you might need to think about is who's going to be undertaking that investigation. We can certainly help you undertake an investigation. You just have to remember, if we are part of the investigation, we cannot help you defend that investigation. So you could come to us, we might be able to get someone independent to come in and do the investigation, so we remain separate from it, so we can help you defend it later, or you might just want us to do the investigation itself. It's a matter for you, but we can certainly do both sides of that. But remember, if we do one, we can't do the other. An employee has falsely accused another employee. Do I need to still go through the standard procedures of investigation and discipline, or can I just terminate the employee for lying? Look, this goes back to the reasons for unfair dismissal matters. if you find that you've got an employee who's literally lied about someone else, started an investigation or asked you to start an investigation which you know to be completely false, then you need to start disciplining that employee. Hopefully you've got a policy or procedure that relates to that. Otherwise, use the procedures and apply natural justice in this process. Ask them the question, listen to their responses, consider their responses, and then decide whether it's been serious enough under serious misconduct to terminate summarily. Now, if we go to serious misconduct in the Fair Work regulations, let me just open the book. It's pretty much around 1.07. Here we go. The meaning of serious misconduct includes willful and deliberate behaviour by an employee that is inconsistent with the continuation of the employment contract. Could fall there. Conduct that causes a serious and imminent risk to health and safety of a person or reputation, viability and profitability of your business. Could be that. Conduct that is serious misconduct includes an employee includes each of the following. The employee in the course of the employment is engaging in theft, fraud or assault, has been intoxicated at work, or is refusing to carry out a lawful and reasonable direction. Now, these ones don't apply if the employee is able to show that in the circumstances the conduct engaged was not conduct that made the employment period of notice unreasonable. Now, that's a really interesting question that actually goes back to this original matter of summarily terminating without notice. Doesn't mean that you can just go, right, you're gone. It actually means that they don't get their pay in lieu of notice, or they don't get their notice period. So it's really actually not okay just to terminate someone for serious misconduct unless you've got some very, very obvious reasons to do it on the spot. Yeah, it is better for you to notify your employee that they've got it wrong. Ask them to respond to that, even if it's a show cause notice as to why they should be terminated, and ask for a response, because you should really deal with first, notifying them of what they did wrong, asking them if they've got anything to say about it, and then genuinely considering that. So you really ought to still comply with that, except if it's a really serious issue, and without a shadow of doubt, it's going to be a no-brainer that person needs to be terminated. And that could be caught on video stealing or hitting someone, or it might not mean that. Okay, an employee has raised a complaint about another employee bullying her. Can I terminate that employee for making that complaint? It just means more work for me if I do not believe the person is actually being bullied. Yeah, look, I understand that. It always means more work. The fact is, you own a business. Part of that business is to comply with the Fair Work Act. The Fair Work Act basically says that you need to, give the employee a chance to respond to any issues that might end up in their termination. So you need to give them a chance to talk about it. The process of natural justice means that you need to at least investigate and consider whether it was true or not. Just because you think it's not true does not necessarily mean that it is not true. Look, grievances, disciplinary matters, investigations are all kind of complex for you. They take up time, they take up money, they take up resources, and they take employees away from their jobs. And it changes the story, it moves the message often. So having a policy in place that you can follow when something happens is actually going to be easier for you. That'll make things a lot quicker, simpler, and it'll get better outcomes for you. So we recommend that first of all you think about what sort of policy you want to put in place for when a grievance occurs, and then just follow the story, take the stop points, make sure that you're following that process so it becomes easy, not hard. But yeah, I think you ought to take the time. It's part of doing business. You're going to have employees that are not happy, but it's pretty much your job to make sure that if you are terminating someone, it's for the right reasons. we can certainly help you. We can absolutely help you with the investigation. We can absolutely help you with the letters. We can absolutely help you with getting responses back from your employees. We can talk about the investigation. We can talk about the termination, and we can help you with all those things. So don't feel alone. It could be a big issue, but we can certainly help you make that a little bit easier and a little bit less complicated, and let's get some clarity into this. Thanks for watching.